Went in where and told what?
When you went in and told the defense.
Oh, okay. Well, it became clear from the last hearing, last motion that was heard in the proffer that the state had offered, that the state and the defense and the court have a fundamental difference of understanding about the laws of conspiracy. And from the direction of the court's ruling that you can't steal the appropriation, we would not be able to prevail to show a theft, and so the state felt like it was in the best interest of this situation to attempt to get the college its money back by offering a diversion. We were prepared to enter a proffer. I do want to say that Dr. Richburg, from our perspective, was used in this process using those PICO dollars, and that he was willing to come forward and testify that he had met with both of the parties, but it doesn't matter if that is before the appropriation. Once the appropriation was put into place, Dr. Richburg, and even in the interim period time when it was before the governor's office signed the legislation, he was doing all he could do to protect the best interest of the college, and so that's why we entered into the agreement with him. We felt that we would not be able to prevail in light of the court's last ruling that there was a conspiracy to commit theft. Even though we've had 7 motions to dismiss, all of which have been denied, and I don't know if y'all want to get into the nuance of
Willie,
of
can you explain what were you trying to do with that motion that resulted in the judge's ruling? What were you trying to do there?
Well, what we have to do in order to get in a statement of one conspirator against another conspiracy, before you can do that, you have to establish that there was a conspiracy. And a conspiracy is an agreement to commit an illegal act. And of course, the court's ruling was that, as we understood the court's ruling, as much as we could understand the court's ruling, was that you can't conspire to steal the appropriation of the legislature. And so if you can't steal the appropriation, how can you conspire to steal the appropriation?
And what do you think this decision says about politics in Florida, and what do you think it says to taxpayers in Florida?
Well, there's a lot I could say. I don't know that I gain a whole lot, especially in budget times. I think probably all of y'all sat in the courtroom and heard how the process works. 2 people sit down and decide how to spend $2 billion, and you had a person who is one of those 2 people. Well, what was this $6 million about? I know nothing about it. It was my opponent's project.
And what do you say to those who says this is the political process, this is not a crime?
What do I say to someone who says that?
Yeah, because a lot of people throughout the trial have said this is really the political process, perhaps, however unsavory, but not necessarily a crime.
Well, I will let y'all draw the conclusions about the political process. I think you saw it operating in this particular case, and so I'll let y'all draw that conclusion about the political process.
So from a legal standpoint, do you agree with the defense then that nothing wrong occurred?
Oh, no. I agree that the state was not able to carry its burden of establishing a conspiracy and with the court. And so if I can't establish a conspiracy with the court before the appropriation, then I can't get in statements of co-conspirators after the appropriation. And that's what all of our evidence is about, is what they did after the appropriation was put into place.
Billy, can you explain again exactly what did you agree to for the no price?
In this negotiation, we were prepared to move forward with a proffer of some testimony, but the testimony we were going to proffer was pre-appropriation.
Okay.
And our understanding of the court's thought process was pre-appropriation doesn't matter. It's after the appropriation that matters. Well, if I can't get in before the appropriation to establish a conspiracy, then I can't prove the case. So once we felt like we were in that particular posture,
These were statements by Mr. Richburg.
they were statements by whom?
They were statements by Mr. Richburg that are at issue here, correct?
Well, we were going to use Dr. Richburg to establish the conspiracy, but that was before the appropriation. If that is not relevant to the court, then we could not establish, we didn't feel we could establish the appropriation. So that was the hint, that was the direction that the court was leaning. So we made a decision during the lunch hour that, and I don't know how he would have ruled had we made the proffer, but we knew what the proffer we were going to make was. And we made a decision that we felt it was best to get the funds that have been expended on this project returned to the college by the defendants, and they agreed.
So what was that decision? What does everyone agree to do?
They're going to make restitution to the college for each one for $103,000.33 apiece. And Dr. Richburg is going to do that as well, so the college will be made whole to the tune of $310,000. Of course, we're going to, now that the case is over, we had entered into a diversion agreement with Dr. Richburg that he would do community service. Actually, he has been doing community service and is doing quite well with it. And he probably will continue on doing community service. But in light of the fact that as soon as we get the restitution, we're going to drop the case against the defendants Sansom-Odom. We're going to drop it against, we've already dropped it against
Dr. Richburg. So these are essentially PTIs or diversions that they've agreed to,
No.
correct?
No.
What are
They're
they?
going to make restitution and the case is dropped.
Okay, what if they don't make restitution?
I sometimes carry a gun, and I'm going to gun down 2 defense lawyers. So yes,
All right, easy does it.
So you're saying you couldn't prove a post-appropriation conspiracy to steal this money? There's no evidence of that?
Oh, there is tons of evidence of that, but I can't get to that until I establish that there's a conspiracy.
So can you explain more for us non-lawyers, what you understood the judge saying, that basically you cannot establish something of a pre-appropriation?
Our understanding of his ruling is pre-appropriation is immaterial. It has to be once the you can't conspire to steal an appropriation. And Eddie, I think that's basically the sense that we had, but now after the appropriation, you could take the appropriation and you could steal it, the use of it.
Thanks.